Welcome to the Sacramento Injury Law Podcast.
Welcome to the Sacramento Injury Law Podcast with Brian Jacobsen from Aiken and Jacobsen. I'm Lisa Mosbey, your host, with decades of experience fighting for the injured across Northern California. Brian is here to break down who can be held responsible after an accident and why it's not always as straightforward as it seems. Welcome, Ryan. Thank you so much for bringing clarity to this topic today.
Hi, Lisa. Good morning. It's nice to see you again.
Thank you. Brian, who can be legally responsible for an accident in California?
A lot of people.
Yeah.
The easiest way would be, or the most common way, I should say, is what they call negligence, meaning someone's liable for an accident if they act negligently. And again, that's more of a legal term that people probably, what does that mean? It just means that they failed to use reasonable care. The easiest way is you get rear-ended on the freeway. The person who rear-ended you obviously was not using reasonable care. That's negligence, and that's a pretty straightforward way of doing it. It's proving, from my perspective, it's proving that there was a duty of care that was breached, meaning to act reasonably and not run people off the road or crash into them, for instance. But it also, it involves factors like speeding, distracted driving, intoxication, certainly, ignoring traffic signals, going through a red light, that sort of thing. That's the most common way. We can talk about some others, and I think, we probably should. But that's, like I say, that's the most common way to find somebody responsible.
I do want to get into some situations where responsibility extends beyond just the person directly involved in the accident.
Sure. The other way, or some of the other ways, one would be what they call vicarious liability. Again, that's a legal doctrine, but it just means that one party is going to be held responsible for the unlawful or negligent actions of another. And again, going back to negligence, but that's just they failed to do their duty of care, and they've acted unreasonably in some manner. Usually what that takes is a special type of relationship. Maybe a boss-employee type of a thing. If you're, I hate to do this, but let's say you're an Amazon driver and you crash into somebody, not only is the driver responsible, but also Amazon, the company, because that person is, if that person is working in the course and scope of their employment, that would be a way of doing it. Again, another way would be if you're in a hospital and something goes wrong and the nurse does something wrong to you, not only is the nurse responsible, but also the hospital may be, depending on the facts of the situation. A lot of it depends on your employment. That's one way of doing it. That's why you see in many cases the Uber and Lyft people trying to get described as independent contractors, because again, they're trying to break that employer-employee relationship in the hopes that if the Uber or Lyft driver does something wrong, they're sort of, you're on your own. You're not coming after Uber, or you're not coming after Lyft. So again, it's a lot of it is fact-based on our part, where we need to find out. We need to show some things of, was that person an actual employee as defined by the law? If so, then you can obviously get the employer.
One of the words that I've heard you repeat over and over again is the word negligence. When I hear that word, I think of a criminal aspect to what happened. Let's talk about that word.
Sure.
How strong is it? What does that mean to somebody who's been involved in a personal injury lawsuit?
It just means that somebody did something wrong. I mean, I guess the easy way or simple way to define it would be, you've done something wrong that a reasonable person wouldn't do. Again, it can be as easy as, I just rear-ended somebody, I blew through a red light, things like that. When I'm driving, I'm not, as a reasonable person, going to do those things. And that's what we as attorneys need to prove for a big part of our case. I mean, it needs to be proven that that other person did something wrong, so to speak. And negligence is a legal term, but it's easier to think of if you just, did that person do something wrong that a reasonable person wouldn't have done? If that's the case, then there's probably somebody to go after.
I understand. And then how does liability work when someone causes an accident while they're on the job? You mentioned a couple of different companies that those cases could happen under.
Mhm.
How's liability allocated?
Well, again, it's always going to be on the driver, the person who was the most responsible for it. So, again, let's take that example that I was just talking about. Let's say the Amazon driver
Mm.
working for Amazon at the time rear ends me and causes an accident. I'm going to sue both Amazon and the driver named specifically, but ultimately it's going to be the actions of the driver that are the negligent part of it. But Amazon is going to pay, or their insurance company would pay in that situation, because the driver who is responsible was working for them at the time.
And how does the owner of the vehicle affect it? Because they were driving it, but they're driving a vehicle owned by Amazon. So that's how Amazon gets pulled into it in this example. We're not
In that
saying that
example, it would
Amazon.
be.
Yeah.
Oh, I'm sorry. Go ahead.
Oh, I just want to, I don't like to use a specific name. I don't want to say, Amazon drivers. Yeah. But people who are in vehicles for work, whether it's a truck driver, a delivery service, a retail service, those folks are often, on the road for many, many hours and things can happen. I'm just wondering what happens when the person driving a vehicle isn't the owner.
Well, again, it would depend if we as attorneys can show an employer-employee type of relationship, then that puts the owner on the hook potentially. The other scenario would be, let's say I loan you my car, or how about we'll do it this way so you're not the bad actor. You loan me your car and I go out and get in an accident. Let's say I don't personally have any insurance, but if I was driving your car with permission, then they would come back after you because more than likely you've got insurance because of the car. So that's how the owner would be involved. Um, a lot of times, you give your car to your child or whatever it is, and they go out and get in an accident, but they don't have insurance. The owner is still going to be responsible for it. So the owner is still going to be on the hook for um, certain amount in California based on the fact that they permissibly let that car be used by a child or friend or whoever.
And how do cases look different when an unsafe property condition plays a role in someone getting hurt?
I wouldn't say they look different. It's just obviously a different set of facts. There's what we call premises liability, meaning that, again, if there was a defect or a problem with the property, that may cause responsibility on the owners. Let's use an apartment complex, for instance. They've got a bad set of stairs that people have been complaining about for months, and I go walk down these stairs, and lots of people have fallen before. I fall, break my leg. I'm going to go after the apartment owner because more likely, we would need to show that they knew that there was a problem and they failed to do anything or take any remedying steps to try and fix the problem.
And again,
But
that's negligence on their part.
Right. It's negligence on their part, but again, it's just a different set of facts. We've got to prove some different things to prove that they knew about the condition, for instance, versus they probably, in most cases, maybe wouldn't actively have done something, but they could have. I mean, if they had actively wrecked those stairs that I fell down and broke my leg, then they would be in trouble for doing that too.
The other one that comes to mind is defective products. What roles
Right.
do defective products or equipment play in determining responsibility?
Right. And that would be one where what they call product liability, but it's based on a strict liability theory, again, a legal term. But what that means is that we as an attorney would go after either the manufacturer, the distributor, or possibly the seller of the defective products. And really what that claim relies on is we've got to find that there was a defect that existed. Doesn't matter if it was intended to be that way or not, just that there was a defect in the design, manufacturing, or warning existed when it left the defendant's control, and that caused the actual injury. An example of that would probably be, a defect in the car, for instance, that caused you to crash. Back in the 80s, I think it was they had the problems with I can't remember, I think it was the Ford Pintos. Hate to use a name, but I think it was a Ford Pintos where you'd crash into them and the car would blow up. And again, that was a defect in the way that it was made. There are all kinds of defects, and one of the things that they try and the other side will try and do is, did you make any changes to it? A saw cuts off your hand. Did you take off the guard? Things like that. Those are all the facts that we would need to look into to try and figure out whether there was actually a defect or whether the person had some responsibility in making it a defect.
So you approach those cases that the insurance company tries to shift part of the blame onto an injured person. You treat them with a lot more investigation and research.
Yeah, well, that's about every case.
Yeah.
Insurance company, unfortunately, wants to shift the blame on everything. And really, the only way around it is to do my job, and that is, again, a thorough investigation, like you said, to look into the facts. It may be looking into the person's past medical history because, again, insurance companies love to, you've been injured, for instance, and you've had back pain before, and now you're having back pain. They're going to try and say, well, this accident didn't cause any problems. This was all due to your prior back pain.
Mm-hmm.
And again, that's part of my job is I want to look at all the medical records, see how, were you treating? Had you ever complained about it? Maybe it'd gone years where there had been no complaints of back pain. You get in this accident and all of a sudden you need a back surgery. The insurance company's not going to like that, but that's an easier way to prove that the accident was the complete and total cause of your problems versus maybe some old injury that the insurance company is trying to hang their hat on.
Sure. So what does your team look for early on that might reveal additional responsible parties?
Again, it comes down to a thorough investigation. We're looking for anybody that's involved. We may have a case where, there's several parties involved. And if you've done your investigation and you found those extra parties, maybe it's another person to, potentially pay damages for. Maybe it turns out that's a responsible party. If it's for instance, it's a multi-car accident. A lot of people have caused or had some hand in causing the accident, but the main actor was a hit and run. Well, if we can track down who that hit and run person was, maybe that opens up the door to going after the majority of the liability. Again, it just comes down to doing a good job for the client, given the set of facts, and that's going to be based on an investigation. Looking at everything, talking to the witnesses, talking to, friends who may not think they've seen anything, but maybe they do. And again, that goes back, I think we talked last week or last month of how to do this, but you want to get in early to try and figure out what's going on.
Here's where I want to wrap this up today, Brian. How does it identifying the right parties, the right responsible parties, how does that change the strength or value of the overall case?
Well, it can change it in a couple of ways. Again, it would change it in the way of maybe you found the responsible party. If there's liability split between different people, maybe by doing that investigation, you found the person who is most responsible. So that may be important. Maybe it turns out that that through the investigation, you found the person with the adequate amount of insurance to help pay for the accident, where the people that you had early on didn't have enough insurance because the injury was so significant. Again, those would be the ways that I would think that getting the right party, you always want to get the right party, but maybe doing a little investigation might help you find additional parties that would help split the cost so that the person is actually made whole when the case is settled and done.
Well said. And I think we'll leave it there. I do believe we achieved our mission of creating some clarity and understanding around this. So thank you so much for your time today.
Thank you very much, Lisa. It was nice talking to you.
Folks, thank you for listening to the Sacramento Injury Law Podcast. If you have questions about your own case or need expert advice following an accident, visit Brian at aikenjacobsenlaw.com to schedule a consultation. Don't forget to like, subscribe, and leave a review, and we look forward to seeing you on the next episode.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.